Hey, it's James, Father's Rights and Resources, hashtag HowiGotCustody. There's this legal principle called substance over form. And a lot of legal principles are laid out in statutes, and court rules, all that public policy stuff, everything that's public policy. But a lot of there's some legal principles that are established via case law or common law, which was the intent of being in a common law state. Cultures change and cultural norms change, so a common law state will acknowledge that, and then some of the biggest examples are like through common law, abortion used to be illegal and now it's legal, or separate but equal is considered equal. Black people having their own separate school, their own separate water fountain, their own separate place on the train. And then it turned out when people woke up, oh, that's not fair and that's not right, because the oppressive people were writing the laws and stuff. So right now, the feminists or the pro-mothers or the anti-father people are writing the laws and the public policies and things like that and making rulings in higher court. So, like, there's a case in Washington where a mom became a paraplegic and she went through, after a car accident, she went through some physical therapy and got her physical abilities restored as best possible. And the dad was taking care of the kids for like 6 months to a year or something. So he petitioned the court to modify. And they said, well, that was just a temporary acquiescing to his care in the meantime. So they basically, in their prejudicial setup, they made a ruling in favor of her. He had a winning argument because the kids were left in his care and the mother couldn't handle them. But they placated to her because of their bias and prejudice. So common law is there to hopefully weed out the cultural errors or screw-ups or whatever. And so that's called a common law state. Just a little extra freebie in here. But I wanted to talk about substance over form, because people keep asking about court forms and where's the form for this and where's the form for that. Sometimes there aren't specific court forms or anything. Sometimes lawyers, which they're supposed to be, are smart enough to write up something that's consistent with the law. The law says if you ask the court for this or that, then you can get this. The law says in Washington, if you live with somebody who's violent, you should get full custody. So when I write up a piece of paper saying I should have full custody because the mom lives with a violent boyfriend, then my paperwork will say in there, RCW 26.09.191 to, maybe it's 2B. The mother lives with a violent felon. Here's him. Here's a picture of him. Here's his record. Here's him toting a gun on social media. All that stuff. And the law says this. And the format that I write it in doesn't matter as much as the content. The law is there to protect children from somebody dangerous that lives with a parent. The court should care more about the substance of what I'm saying than the form. If I go outside of the margins a little bit, or if my page limit is 10 pages and I write up my argument 11 pages, do we care more about the substance or the form? If it looks sloppy or it's handwritten, do we care more about the substance or the form? One great example of substance over form prevailing, and I get a lot of, there's not a court form for every single thing out there. And a lot of courthouses don't have a lot of forms available. Some of them have a lot. But some of them have something like Washington has a motion for an emergency order, a motion to waive the filing fee, a couple of certain specific things. And but there's a million types of motions, so they can't have a motion for every single thing out there. So that being said, you have to customize your own motions sometimes. And if you do it not, that's why it's good to know the court rules. Okay, 3-inch margin in Washington, 3-inch margin on the top of the first page, and that the whole point of that is so that the clerk can stamp the court papers with their receive stamp. There's a space at the top for receive stamps for the law firms, for the court, or whatever. And then the next pages have a 1-inch border all the way around. Well, and then the Court of Appeals in Washington, you have a 2-inch border on the left side and a 1.5 on the right, and it's 1.5. It's 1.5 all the way around, but it's 2 inches. I think because the books that they put the reporters in are really small, so they want small print. I don't know. They're weird. So if I go outside that border, sometimes, and people have done that before in the Court of Appeals, and the Court of Appeals lets it slide because they recognize what's more important, the rules of the law and whether a judge violates somebody's rights or the technicality of this paperwork. So that being said, if I go to court and the court said, well, you did your paperwork wrong, you went over the page and stuff, you care more about the substance of what I'm saying or the form of it? You care more about truth and justice or a typo or a technicality or a paper mistake? What do you care more about, Your Honor? Justice, truth, and facts and the welfare of children, or helping the other side win on some stupid technicality? That's harmless error. It doesn't harm anybody that I went a page over, or that my pleadings were out of line for a second, or whatever might be something wrong with the paperwork. Or I've seen judges make rulings say, we'll use the improper form. Well, if they use the proper form with the proper form number at the bottom, the forms are like, I remember some kind of motion or something. The different forms were very similar. If that guy used the different form with a different form number, he would have to copy, I think it was just a cover sheet. It was like he used a confidential report cover for like a guardian ad litem or forensic psychologist instead of the sealed healthcare records. Well, they're both sealed covers to protect the filing. So what's the biggie? What's the big deal? Who is it harming? You got some stupid jackass lawyer who was super anal about which forms to use when they're practicing law. So when they get on the bench, they apply their mentality and the culture of their law office instead of the rule and the law and the leniency for the sake of justice, or waiving a filing fee, or not waiving some error that's harmless error and doesn't prejudice or harm anything. The whole purpose of rules in the court is for everybody to have a fair hearing. If everybody got a fair hearing and a chance to speak, what's the big deal about some technicality or some rule here or rule there? But judges will do that, and nobody calls them on it because these lawyers are a bunch of punks and cowards. But you guys should do it. I call the judges on their stupid petty crap. Like, if your kid gets in trouble, but they're trying to do the right thing and they're learning as they go, do you have compassion on your kid, or you punish them and ground them for a month because, I don't know, they used the vacuum because they wanted to clean the house and they wanted to help out and their heart was in it, but then they broke something with the vacuum? Do you punish them like you would if they picked up a piece of glass and threw it across the room and shattered something on purpose? No. You look at somebody's heart and their motive. So things kind of depend on the heart behind it, the motive behind it, and what people are doing. If I'm going over a 1-inch margin rule or a page limit, am I trying to harm somebody and disturb them and destroy their life? No, there's no harm or prejudice to them. What's more important is the substance of what I'm saying, especially if the law is in my favor. Substance over form, okay? The greatest example of this, I think, is Gideon versus Wainwright. There was this guy named Gideon, I forget his full name. I think there was a movie done about him, or a book called Gideon's Trumpet. Gideon's Trumpet, that's a biblical thing, but they use that catchphrase to get attention for their book or whatever. So this guy named Gideon, maybe he robbed somebody, maybe he didn't. He walked out of a bar with somebody's money, and they pressed charges, and then he was thrown in jail, and he asked for an attorney, and the judge said, you don't get a right to an attorney, this is only a misdemeanor, that's for felonies. The judge making up his own laws and rules, like a lot of these self-righteous, arrogant, condescending, God complex having, megalomaniac pricks usually do, and sociopaths and sexually deviant perverts who, have sex in the courthouse, sex with clerks, use their power and position to get free, cheap, and easy sex, or molest boys like that Seattle judge did in the 80s. If you Google Seattle Times judge kills himself in chambers, you'll find there's a child molesting judge in Seattle and King County. When it was getting in the newspaper, he shot and killed himself. The paper covered it up for a while. So did people at the courthouse, because there's a protocol among the elites, right? So in Gideon versus Wainwright, you could Google that. Gideon versus Wainwright. I think it's Wainwright. Gideon went to jail. He didn't get a right to an attorney, so his due process rights are violated. Anytime the court, the government, or anybody takes something from you, money, a fine, a parking ticket, there has to be due process. The Constitution basically says that you won't be deprived of life, liberty, or property without due process. Property is your money. If they say hand over money because you did this and you didn't get any due process, like all these street lights that have cameras, there's no witness testifying against you. It's a camera, and then somebody verifies on the camera that that's that. There was no witness who saw your criminal act. Those things are to make money for the city. They're not to protect the city. And some of those things, you can write the city and demand their contract with the people, and they sped up the speed of those lights so that more tickets would be handed out. That being said, and that's why it says this will not go on your record, because it can't, because it's totally unconstitutional. But the legislature, saw a judge one time say, well, the legislature has decided that it's okay to do this and hand out fines. And what the judges do at some of these hearings, the judges will call somebody up and say, isn't this you on the video and all this other stuff? And they're questioning them like a lawyer, and they're asking them to incriminate themselves without a right to an attorney. Totally unconstitutional. Anyway, another side note. But in Gideon versus Wainwright, if you watch, not watch the movie, but if you read that case, Gideon was thrown in jail. While he was in jail, he wrote a letter to the Supreme Court, and maybe it was an official appeal on some jail letterhead. They may have had some standard letterhead. He wrote in his own handwritten chicken scratch, I was deprived of the right to an attorney, blah, blah. He took it to the Supreme Court of the United States, and he got in and he won, and he got a reversal on some jailhouse letterhead chicken scratch in his own chicken scratch. Now, if we cared more about the form of something, they could have said, well, this is ugly handwriting, you should have typed this up, that would have been prettier, we're going to reject it. The Supreme Court cared more about the substance of his constitutional rights being violated than they did about the form that was in. Substance over form. So if I'm ever in court and the judge says, well, I don't like your paperwork, the wrong form, the wrong format, and this, that, say, Your Honor, substance over form. You care more about justice, truth, and the content of what I'm saying than the format that it's in. Look at Gideon versus Wainwright. That was on some jailhouse letterhead and written in handwritten chicken scratch. Are you going to hold up justice in the legal process and make another delay? Or are you going to follow the code of judicial conduct and the oath of you as a judge to expeditiously expedite your cases? You're going to make us go back and start all over again because of some technicality and technical error? Do you do that with all the attorneys when they make countless errors? When their paralegals make countless errors? Or do you cover for them because they're part of your bar association brotherhood and they're in the club and I'm not, so I don't get justice? Even though taxpayers pay your salary and you serve them for the sake of justice and truth, and you administer justice and make sure that that's administered in your court. Or are you going to play lawyer games because when you were a lawyer, you lied and played games and manipulated and stuff, so you'll go along with their manipulative games instead of getting down to the facts and the truth and giving everybody an opportunity to be heard? What are you going to do in your courtroom? You're going to hold up justice and delay it? You're not going to listen to the content of what I'm saying, even though there's a public policy on substance over form? Now, you could probably do, like if you're in Georgia's Supreme Court, substance over form. You might find that in case law. I don't know. I've thrown it out. It's a legal policy that's well known. Some of these policies are well known and people know that it's somewhere out there. Just like the right to an attorney, the right to remain silent. You may not be able to go find it or quote the initial case off the top of your head that it was laid out in, or that somebody won in the Court of Appeals and now it's the new legal principle. But there's some things that just people know that they know. So I use substance over form. If you want to use it, go ahead. Like the Hodge twins used to say in their workout videos, you could do whatever the blank you want. So, substance over form.